Of State versus J.L.G. May we please have appearances of counsel?
Good morning, John Security of N.J.R.E, appearing on behalf of curiae, the last resort accommodation project for Seton University School of Law.
Good morning. My name is N.J.R.E. I'm appearing today as the amicus on behalf of the Association of Criminal Defense Lawyers of New Jersey.
Good morning, on behalf of N.J.R.E, New Jersey, Friends of Court. Good morning, Assistant Prosecutor Rama, the Hudson County Prosecutor's Office, appearing on behalf of the state.
Good morning, Sarah E. Prosecutor, Attorney General, on behalf of the New Jersey Community.
Welcome, counsel. Please be seated. Ms. Michaels, go right ahead.
Thank you. May it please the Court, I'd like to reserve just a few minutes.
Keep your voice up and we'll have you back.
Great, thank you. For years, so-called child sexual abuse accommodation syndrome experts have been testifying about Roland Summit's 1983 theory. And the state has consistently come into courtrooms around New Jersey, including this courtroom, asserting that CSAAS, as theorized by Summit, is valid, reliable science. In this case, the court remanded to finally put the state to its proofs. The remand order was clear: to hold a hearing to determine whether CSAAS evidence meets the reliability standard of N.J.R.E. 702 in light of recent scientific evidence. And what did the remand ultimately reveal? After years of championing Summit's hypothesis as, quote, a common denominator of the most frequently observed victim behaviors, now, when asked to provide proof, the state has retreated. For decades, the state has asked this court to allow CSAAS testimony on the basis that it explains how children typically respond to sexual abuse, as well as the underlying psychological, familial, and societal forces that cause those hallmark behaviors. However, the research is clear. 2 of those hallmark behaviors posited by CSAAS are in fact relatively rare, and CSAAS's causal claims remain unproven. Since they can't meet their burden, the state now says that CSAAS is just an explanation, that a child can react in virtually every possible way to sexual abuse, and any behavior that a child exhibits is recognized, understandable, and a reasonable response to sexual abuse. The state's attempt to recast CSAAS as something other than Summit's theory is the very definition of pseudoscience. CSAAS is so malleable that this court has repeatedly been left to set constraints on this boundless catch-all concept. And so-called CSAAS experts have shown time and again that they are unable to confine themselves to those constraints. The need for legal corralling of CSAAS is a constant of this court's jurisprudence. That wouldn't be the case if this was a clearly defined and consistently applied, reliable scientific theory. Basic tenets of science, including social science, are that there's a common precise vocabulary and definite parameters, a well-defined hypothesis, controls for bias and error, and consideration of confounding factors, and drawing only the conclusions that the data allows. CSAAS's proponents can't even agree about what it is, when it applies, what the relationships are between its parts and various subparts. CSAAS is conjecture in search of facts. It assumes abuse, says any behavior or its opposite can be present, and this is consistent with abuse. This court knows that social science can be validated, repeated, and proven. Experts can agree on core concepts, precise terms, and definite relationships between variables. We did it in Henderson. Observational science can be valid if done the right way. But even the results of well-designed studies are only useful to the extent that they aren't stretched beyond what those studies are designed to show. The infirmities in the state's case aren't because it's social science, it's because it's pseudoscience. After presiding over a week-long hearing focused on the state of scientific evidence regarding CSAAS, a very experienced assignment judge faithfully applied Rule 702 and in a thoughtful opinion arrived at the conclusion that CSAAS is not scientifically reliable or generally accepted. The state failed to meet its burden. Judge Barissa's decision was based on sufficient facts in the record, and his legal reasoning was sound. His decision should be adopted by this court. Courts have a critical gatekeeping function to prohibit criminal conviction by pseudoscience, and in this case, Dr. Tasca's lengthy testimony about CSAAS infected the entire trial of J.L.G. and rendered it unfair, and therefore reversal is required. And that concludes my opening.
Judge Barissa largely agreed with what you've said, but he found a general consensus as to one of the 5 components of CSAAS, delayed disclosure. And it appears that there are a number of expert reports, the Elliott study, the London study of 2005, the London study of 2008, and others, the expert testimony at the hearing, that support what Judge Bariso concluded. Why is evidence simply of the question of delayed disclosure not state-of-the-art within the meaning of 702? Should that, can that, and just that piece for this question be permitted to be introduced?
So I have, a multi-part answer to that question, as I'm sure you would expect. So first of all, CSAAS has been consistently proposed as a unified theory. So allowing in CSAAS testimony for really just this one piece of empirical information that is generally accepted, that delayed disclosure and delayed allegations of sexual abuse are common, would be inappropriate. In terms of the question of just that one issue about whether the fact of delayed disclosure is something that scientists agree on, that would be inappropriate for expert testimony, I think really in any case.
So why shouldn't it be the subject of a jury charge, like a Henderson charge, or like a fresh complaint? Why shouldn't we, the judiciary, be informing jurors that delayed reporting is not abnormal and therefore should not work against the credibility of the child? Forget about having to put on experts, but informing the jury about a notion that no one seems to even disagree about.
So just to clarify, you're asking about a jury charge that doesn't talk about CSAAS but just says delayed disclosure happens.
Exactly.
As I think there was a lot in my brief about whether or not this is beyond the ken of the average juror, and I would argue that it isn't. Even putting that aside, if this court disagrees, I think that you could have a charge that is a fair and neutral charge. I do actually have a proposed charge if you'd like to hear it.
What about a jury instruction? Mm-hmm. Since most defense counsel, I presume, are going to attack the delay in reporting. And what about an instruction at that time to the effect that delayed reporting is common?
So again, talking just about the
delay in reporting.
Yeah, I think that as long as the jury instruction says
Let's
that.
hear your instruction.
Thank you.
Sorry.
I typed it down. No, that's okay. I typed down everything. You may recall that evidence that complaining witness did not complain immediately. You may recall that complaining witness did not complain immediately after about the alleged sexual abuse. Children sometimes delay making a complaint about sexual abuse, both in situations where the abuse occurs and in those where abuse did not occur. You may consider the delayed complaint along with all the other evidence, including the complaining witness's explanation for the delay, when you decide how much weight to afford the complaining witness's testimony.
Does it really make sense? I'm sorry. Does it really make sense to give a jury an instruction on delayed disclosure of an event that didn't occur? I understand why you want to make it a more balanced instruction, but isn't the point that when abuse actually occurs, there is delay? To say that children or sometimes delay disclosure when it didn't occur doesn't seem to make sense.
But that is actually what the expert testimony in this case said, that we don't know that delayed complaints about abuse happen any more or less frequently when the ground truth of that is that it's a false allegation or a true allegation.
I understand where the expert's coming from, but to tell a jury that there's delayed disclosure of non-abuse seems a little strange.
Well, I think that's why when I was thinking about the charge that I would propose to you today, I think that's why using the language delayed complaint makes more sense, because the word disclosure sort of has baked into it that you're disclosing something that's true. But really what we're talking about is, in talking about delayed disclosure, what you're really talking about is the timing of the allegation.
Why shouldn't the state be able to, let's focus our attention on that one aspect of CSAAS that is agreed upon as being within the scope of 702. If it meets 702, why can't the state put on an expert to say, with very disciplined testimony that doesn't veer into the facts of the case, doesn't encompass all children, simply have a very focused expert opinion that says that that children who are abused sometimes delay disclosing and sometimes substantially delay disclosing, and secondly, explaining maybe why that occurs.
Well, that sounds like, respectfully, that sounds like CSAAS, what Your Honor is saying. It is not generally accepted as reliable that CSAAS is the cause of any of these delays. We have
Take CSAAS and the other four factors
Okay.
out. I'm leaving those out. Why is it not within the scope of 702 when there is agreement that it is generally accepted, meets the Frye test, to have an expert very briefly and in a very disciplined way explain to the jury that sometimes children who are actually abused delay disclosure?
Without the reasons why. I'm sorry. I thought that the first thing that Your Honor
Okay,
said.
well, let's just stick with that point for why is that, if it meets 702, why is that not an appropriate expert? It's not within you're not arguing that most jurors know how children react to sexual abuse,
Oh,
are
I
you?
am. I mean, that is part of my argument, that that's something that is within the kind of the average juror.
So there may
just to
be,
be clear about
but there may be a situation where a 10-year-old freezes on the stand when questioned, and freezes earlier during the pretrial investigative phase when asked, "Why did you wait so long to speak?" Potentially beyond the ken of the average juror to understand the reasoning then. So put that to one side, and we'll come back to it. Why not allow the testimony? If there's sufficient expert evidence to allow a jury charge, wouldn't it logically follow that you could put the expert on the stand, limited to this one area?
So the specific case that you just spoke about, there would be something specific in that. So the issue in terms of the admissibility under 702, it's not just whether there's there's generally accepted science to support that. It's also all of the other factors. Is this something that the jury needs? Is this something that's going to help
so
the
our,
jury?
our question to you, I think, is
Okay, I'm going to try to answer your question.
reliability. If you surpass the reliability clause and put the other clauses to one side and assume the evidence is admissible under 702, why wouldn't an expert be permitted to testify about delayed disclosure?
I think that this court should still be concerned about having an expert. I understand Your Honor's concern, but any time that you have an expert testify, it's going to impact the way that the jury views the evidence, and perhaps skew it in a way that a charge, well, really all that this is supposed to be, as I understand it.
Isn't that true with all experts, not just experts in CSAAS? Any expert that testifies, the jury gives some weight because that's the purpose of the expert, to help them with some esoteric matter that they may not be able to figure out on their own.
Yes, that's true.
So the argument you pose is every case, civil, criminal, every time an expert testifies, that problem exists.
No, that's true, but that's why we have.
And that's why the jury charge takes care of that, by explaining to the jury that the expert has opinions, that the opinions based on certain facts, they're to determine whether the facts exist or not, and they can give the expert's opinion any weight they so desire, or give it no weight at all. So doesn't the standard expert charge take care of your concern?
So I certainly agree that this is a consideration anytime there's expert testimony. I think what I was trying to get at in starting to say it is that these considerations are why we don't let in expert testimony in every case. I think
here,
that one...
If we have state-of-the-art evidence, studies, experts, and they are deemed sufficiently reliable, don't you get beyond the reliability prong?
Yes, you would get beyond the reliability prong, but you still have 403, and you still have the other evidence rules in a case. I don't think that...
I think 403 would knock out the expert testimony even if it meets 702?
I think it depends on and partially that depends on the facts of the case.
Once defense counsel examines the witness or challenges the prosecution on the delay in reporting, 403 goes by the boards, doesn't it?
Well, it's hard to imagine in what kind of case where there's a delayed allegation that it isn't going to be part of the defense that you need to consider the fact that
Exactly.
that there was a delay.
Doesn't that knock your 403 argument out of the box?
I don't think so. And the reason why is that really what I think we're trying to get at is to not have the jury make like a bad inference. We don't want the jury to assume that simply because there was a delay, this child isn't supposed to be believed. And generally, the way that we deal with inferences is through a jury charge. So, for example, if there's an issue of flight in a case, we don't have an expert get on the stand and testify about the percentages of cases where people are fleeing and are innocent. That's not what we do. We just tell the jury, don't make this inference.
Right, for commonly accepted notions, but then you have to agree on what would be an appropriate charge. So Justice Patterson suggested like the tweak on your charge. I'm trying to figure out what's wrong with her charge.
Maybe Justice Patterson could tell me again what the tweak was.
Justice Albin remembers it better than I do, as usual.
We can work together and figure this out.
You had the and/or. You were trying to, cover the areas,
We're not going to try to write a charge now.
Sure.
The question is whether expert testimony and/or a charge, in light of the state of the science and the expert testimony, would be warranted with regard to delayed disclosure.
So, as long as what we're talking about is the fact that delayed disclosure happens, or delayed complaints happen, both in cases where children are abused and not abused, then, that does pass the reliability standard.
Why? This is the problem.
But I don't know why we need an expert.
In the cases where why are we including cases when they're not abused? We're only if we're concerned with a case of abuse, why are we including some other category of case? Like, why aren't you just limiting it to in cases of sexual abuse? It is not uncommon for children to delay making a complaint. Like, what's wrong with that?
Well, the reason why I keep pressing the issue on this is that that I think that there's a problem with telling jurors that what you see here isn't uncommon when
maybe there's something wrong, and the Chief is right about not crafting it. So I'm not saying that the language that I'm advancing is perfect, but ultimately it's for the jury to decide, whether or not this is that such a case or it's not such a case. But just so that they're informed that this happens, and the fact that the complaint hasn't been made should not be held against the child's credibility.
Well, I think that last bit that you said, I think actually would be a problem. This is something that should be factored in along with everything else about
So I agree with that, or not necessarily, whatever the language is, because the jury is the final fact finder as to the credibility of all the witnesses.
Yeah, then I actually don't think there's much space between what you're saying and what I'm saying, Your Honor.
When you say a delayed complaint, are you saying that the data shows, and obviously I'm very well presented on all sides here in terms of presenting to us what was presented to the trial court and the data. Does the data shows that children who are creating a false allegation say it happened, this is what happened, lie, and it happened a year ago? Is that what you're...
Yeah, and actually... And I would,
what is the delayed complaint in a false accusation case?
Well, and this is just a hypothetical case that I'll say. So, for example, like in a case where there's a custody dispute and the child is pressured by one of the parents to say that the other parent, abused them in the past.
That's not a criminal case.
Well, but those are cases that can go to trial.
But that's not what we're talking about. You're talking about a family custody dispute. That is a totally different scenario. If that family member gets prosecuted later based on that allegation.
Right, and that's what I'm talking about. I'm trying to give an example of where you would have a child who's making an allegation about something that happened at some point far in the past that isn't a true allegation, or that the allegation itself isn't true. So, because that's what we're asking the jury to figure out, right? We're asking the jury to figure out whether this allegation is an accurate allegation or not. And so I think we need to tell them that this is something that happens. This is something that happens in cases where ultimately the child was actually abused, and also in cases where it wasn't. And that I think that's clear from the evidentiary record in this case. If the court doesn't have any other questions sort of generally about CSAAS and instructions, I did want to talk about J.L.G's case in his trial. So in this case, the CSAAS evidence infected the entire trial. We have the prosecutor open to Summit's theory of CSAAS. We had Dr. Tasca's testimony in this case, which came in before the complaining witness, which this court said in J.R. Should be avoided. We have both Summit's theory of CSAAS. There's also the collection of behaviors, and she included also a host of new things that I hadn't seen before. That if children don't tell within 48 hours, there's a 70% chance of re-abuse. She tells them prevention programs aren't effective. She talks about a vasovagal response. She incorrectly says that children often don't tell when directly asked. And again, because she listed every possible symptom under the sun, naturally some of them did line up with the complaining witness's testimony. And then we also have the prosecutor's summation, where she used the Dr. Tasca's testimony to bolster the complaining witness in this case. She specifically even said, did you hear testimony in this case that would bridge the gap between bad grades and allegations of abuse? So pointing to the fact that there wasn't an expert that was contrary to Dr. Tasca. And I think most critically for this court's decision in Mr. J.L.G's case is this error was not harmless. There was weak evidence in this case, and really the evidence was all based on the credibility of the complaining witness. And I wanted to just go through a little bit the evidence in this case. First of all, there were inconsistencies and problems, just generally speaking, with the complaining witness's credibility. She had a motive to lie. She herself was facing charges of aggravated assault at the time of the trial. She changed her testimony multiple times, and her testimony is also inconsistent with other states' witnesses. There's also the improbability of the fact that her allegation is that this abuse was ongoing while her 9-year-old brother was in the next room with the door open. And the brother's mother, who's also her mother, wouldn't make him available.
In this case, the alleged victim actually gave an explanation as to why she delayed making a complaint. So one could say, well, who needs any science? She just said why she didn't make the complaint.
Speak to the beyond the Ken argument.
To why?
Why was her explanation something that required more?
Why was the complaining witness's explanation?
This is a friendly question. The victim testified and offered reasons. My younger brother, I don't want him to grow up without a father. I don't want to upset mom. Why was it beyond the ken of the jury to understand and evaluate those explanations?
Well, I'm going to see if I understand Your Honor's question, so I hope you'll bear with me if I don't. So this is a complaining witness who I believe was 18 years old at the time of the trial. The alleged incidents happened when she was 14, 15. She obviously was very capable of saying on the witness stand that she was threatened, that she was embarrassed. And these are all things that jurors understand, that in the sense that we all have families. We all understand family dynamics. Probably most people have had at least some passing experience with teenagers and experience with children. We're not asking the jurors to do something that they don't have to do in other circumstances. She gave very specific reasons.
So are you arguing that it was not beyond the ken and that it did not need an expert witness?
Yes, exactly. It wasn't beyond the ken, and also the CSAAS testimony would have also been unnecessary in this case, even if it was something that was scientifically viable, because here we have an explanation that would make sense to jurors if they believed it.
Your position that most people have dealt with teenagers, dealt with kids, have family situations, this is a little bit beyond this. This is accusations of abuse, which normally I would think most people don't deal with in their family relationships. So this is not really something that's so common that if you've dealt with kids or you have family, you'd be aware of how it works. Would you agree with me?
Well, the reason why I bring up the family dynamics and the children is that the idea that someone might be embarrassed to talk about something that happened with their intimate body parts, or the idea that someone might not want to tell on their parent, that's something that I don't think has been shown to be specific to sexual abuse.
But none of the experts neither expert on either side characterize this as just simple, normal childhood, teenage behavior translated into a new situation. I think it's fair to read the experts as viewing sexual abuse of a child, as affecting the conduct of children in a way that just a normal adult-child interaction would not. Would you agree with me?
Not entirely, because there hasn't been anything shown that child sexual abuse in particular is different from some other transgression, is different from some other traumatic experience, or is different from even that's different from adults,
but it's
from adults who know each other.
Maybe I didn't clearly phrase the question. I think your experts, as well as the state's experts, acknowledged that the abuse of a sexual abuse of a child by either someone in their family or someone outside of their family is a traumatic event, and it can change the behavior of children. I think that was a given.
Yes.
So when you say people have dealt with teenagers, people, to assume that many jurors have dealt with teenagers is not the same as saying many jurors have dealt with teenagers who have encountered a traumatic event within the confines of their family or from a stranger. That's a fair statement, isn't it?
Sorry, I'm thinking.
Okay.
The idea that you're going to have jurors that have themselves experienced child sexual abuse, commonly, I agree with that, but
or who understand it in a way
right.
that an expert would not be able to lend some understanding that an average person doesn't have. I mean, there are experts on this. CSAAS aside, there are experts who spend their lives and write to study the impact of sexual abuse. It's not a matter of common knowledge to everyone. Would you agree with that?
Right, and I'm not suggesting that there can never be expert testimony in a child sexual abuse case. If there's something that's relevant to that particular case, for example, if the child has some kind of diagnosed pathology, of course you could have someone testify to that. You can also have a fact witness in a case testify about what the family dynamics are in that case, or about what the relationship was like in that case. So to be clear, I'm not saying you can never have an expert in any child sexual abuse cases, but in terms of this area that CSAAS is supposed to cover, it really shouldn't come in.
Anything else you'd like to add?
Yes, I wanted to just address the evidence in J.L.G's case very briefly. I know I started on it. That really all the evidence in this case was there was almost no evidence in this case that was against the defendant that wasn't connected to the jury's assessment of the complaining witness's credibility. So really, the CSAAS infected their entire thinking about the evidence in this case. For example, the audio recording that was in this case, the way that it came in was that the complaining witness testified that the gaps in the conversation in the audio there were sexual incidents occurring during that, and so the jury's use of that audio recording is inextricably bound with their assessment of her credibility. And I wanted to briefly address the DNA evidence in this case, because I know you hear DNA evidence and you feel like, well, that's really strong evidence, but this is atypical DNA evidence. This was mostly the complaining witness's DNA. There was only a very small amount found from another contributor. And all the DNA evidence did in this case, because this was N.J.R.E DNA, says that the contributor, that the defendant can't be excluded. All it shows is that both the contributor to the DNA and the defendant, or the contributor to the sample and the DNA, both share a very common allele. So this isn't like the kind of case where you have a random match probability that says, that you pick some random person off the street, there's like a 1 in a million, there's a 1 in a quadrillion chance that there's a match. This is actually something that's very common. And again, the complaining witness, even the DNA evidence itself, the value of it is that the complaining witness had said that, these were shorts that I was wearing after an incident, even though she was very inconsistent about when that incident was and what occurred during it. So I did just want to highlight.
I thought the DNA that they identified that was not her, but they had a lot in common with hers, is indicative that it was a family member, not that it was hers. In other words, I thought it was related to the proofs.
No,
the
the defendant's actually the stepfather in this case, so there isn't there isn't a biological relationship.
Then it would have been inconsistent with the victim's case. In other words, I thought it was that there were common factors in the DNA that was not hers and the other DNA found on her shorts. No? No,
there were common factors between because what they try to do when there are these like multi-source, multi-contributor DNAs, they try to, and there are issues with this too, but they try to separate out what is what's the complaining witnesses and what's the other stuff. And the other stuff, that DNA that they were looking at, shares some commonality with the defendant, but it's a very like 1 in a couple of hundred people have that. So that was the point I'm making. It's just that even though there's DNA evidence in this case, this is not what we tend to think of as DNA evidence, and it is connected to her credibility. And that's the end of my outline. So unless the court has other questions, I'll wait for rebuttal. Thank you.
Thanks. Now, a bit of scheduling before we get to the amici. We're going to try to break it around 12:30. We are very fortunate to have excellent, helpful briefs and no doubt arguments to come from all the amici here, all 4 of you. So I say that with an eye toward encouraging you to be succinct in your presentations and focusing in on the areas as friends of the court that you can assist us in not delving into the facts quite so much. Let's try to get through 3 amici before we break, if at all possible. Mr. Zafuti.
Chief Justice, may it please the Court. The Last Resort Exoneration Project agrees that the evidence of CSAAS in this case should have been excluded as unreliable under Rule 702. But we invite this Court to revisit New Jersey's approach to reliability under Rule 702 with regard to prosecution-proffered expertise in criminal cases and adopt the standards set forth in Daubert v. Merrill Dow and Kumho-Tyre v. Carmichael. That is, that courts should be guided by a task-specific approach to evaluating...
Did the defendant raise this issue?
The defendant did not raise this issue below. The scope of this court's remand order, however, states that the trial court should develop a record as to whether CSAAS is reliable under the standard of 702. The remand order did not show any loyalty to Kelly or Fry, but just to the general standards of reliability under 702.
But just to be clear, the defendant has never taken the position that Kelly and Fry should be jettisoned in favor of another standard.
No, Your Honor, it has not. But adopting this approach makes sense, particularly in the case of CSAAS, for essentially 3 reasons. First, a higher standard of reliability, a more exacting standard of reliability, is appropriate in criminal cases, especially where an individual's liberty hangs in the balance.
So let's stop there for 1 second. I thought that the Fry standard, generally accepted within the scientific community, was the more rigorous standard, because when Daubert came down, it said it was loosening the constraints on the generally accepted. So it seems to me, and you can address this in your remarks, that Daubert is going to permit in more scientific testimony brought in by the prosecution than under the Fry standard. Am I mistaken about that?
Justice Alvin, yes and no in this sense. I think what Daubert does is, it's a more exacting standard under Daubert and Kumho-Tyre. What that means is it really elevates the role of the trial judge as gatekeeper. And I think, and the Court of Appeals in the District of Columbia that just adopted the Daubert standard addresses this very concern. And I think in theory and in practical application, Daubert would allow relatively new methodologies that are not yet generally accepted but result in good science in the particular case to be admitted. Whereas Fry will not allow a generally new method that is generally accepted but produces good science.
Isn't that what Alan just said, that Dauber may let more in than Fry?
Correct, but the role of the trial judge is elevated to examine not only the methodology. Fry really is concerned with the methodology that the experts
So isn't this
employ.
the absolute worst case for us to be deciding Daubert? Because I take it your position is that CSAAS is not generally accepted within the scientific community, and therefore violates our jurisprudence under Fry. So why wouldn't we be waiting for a case where it doesn't meet Fry but it meets Daubert?
Because in this case, if you apply Daubert and Kumho-Tyre, what the Rule 104 hearing showed is that CSAAS is not a one-size-fit-all theory, and that if you admit CSAAS testimony and apply it to the specific facts of the case, and the task-specific approach, there is no evidence that a post-pubescent victim, as in the case here, would react in the same way as a prepubescent victim.
You were, in pointing out the distinction between Daubert and Fry, talked about essentially cutting-edge new science. This is old science we're talking about. This case is about old. There's a distinction. There's a dispute as to whether it's science. This case is about an old publication.
Yes,
right. So this is not a case where the evidence might be admissible under Daubert, but not admissible under Fry.
This is a case where I don't think it's admissible under either standard.
Right. Does that explain to you why this issue has never come up before in this case?
I'm sorry, Your Honor?
Does that explain why the issue's never been raised by defendant or by the state?
No, it doesn't. I think this issue, I think that the Daubert and Kumho-Tyre versus Fry standard is appropriate for this case, given the fact that CSAAS is applied in a vacuum, and the testimony below powerfully demonstrates this. The testimony of Dr. Brook, saying that when CSAAS is offered in the courtroom, it's done so in a vacuum. It doesn't necessarily take into account the circumstances of the abuse. Justice Albin, if I can return to your question with regard to Daubert versus Fry, it's more exacting. Fry is concerned with the methodology. Daubert and Kumho-Tyre are concerned with both the methodology and how that methodology is applied in the particular
Why do we
case.
need it here? You've got Judge Bariso basically cutting out most of the CSAAS findings, and in some finding that that delayed disclosure is generally accepted and adopted. Isn't that good for your client here? And why are we arguing Daubert? Why are you arguing Daubert when you sit pretty well the way I'm reading Judge Bariso's findings?
I think to answer your question, I would like to. The Chief Justice's hypothetical in the public defender's presentation, I think, really addresses your concern, Justice Timpone, which is with regard to delayed disclosure. And in a hypothetical where a 10-year-old may freeze on the stand, couldn't expert testimony about this delayed disclosure be admissible? The problem with CSAAS is that it would assume that every 10-year-old or every 15-year-old or every 4-year-old would react in the same way. If a task-specific approach under Daubert and Kumho-Tyre were adopted in criminal cases, the trial judge would be better to be able to evaluate whether that testimony should come in, given the circumstances of the case.
We have a body of evidence now that you're familiar with, introduced in the hearing, many studies that go back a quarter century. Do we need more in order to analyze the admissibility of any of the features of CSAAS at this point?
I think the record is sufficiently developed as to the disagreements in the psychological community with regard to what CSAAS is and how it was first offered.
So do we need more in order to focus on the methodology, your emphasis?
I think the record is relatively complete, that CSAAS really has no methodology. It was at first offered by Roland Summit as an advocacy piece, and it puts forth 5 different theories that are not validated but require validation.
But put
And-
aside the reference to syndrome and all of those characteristics and focus on the part that the Chief Justice is asking about, which is delayed disclosure. Don't we have agreement based upon the studies examined by Judge Bariso that there is empirical evidence to support that children do delay disclosure?
I would disagree, Justice Levesque, and I would point the court to the study of the 2005 study of Dr. Bruck, London and Bruck. It's in our appendix. She speaks to that issue, saying that there is that disclosure happens at varying rates based upon age, and that in a comprehensive review of the literature on this, older children, if I believe I'm stating correct, older children disclose at higher rates than, say, younger children do. But at the time that Dr. Bruck wrote that, the research really wasn't, there are a lot of factors to consider. But I think that highlights why a general acceptance approach or a Frye approach in the context of CSAAS is not the right one. General acceptance is a very rigid
So you
standard.
disagree as to whether or not there should even be ever expert testimony, let alone a jury instruction, just simply about the fact of delayed disclosure among child sexual
Do I agree or do I disagree?
You tell
I
us.
take it that you disagree, but tell us.
I was trying to repeat your Honor's question. Under a task-specific Daubert-Kumo-Tyre approach,
I'm sorry,
after the
task-specific, you said?
Task-specific,
Yeah.
yes. Daubert-Kumo-Tyre approach. After a 104 hearing, there may be, in a hypothetical case, where a delayed disclosure instruction is warranted, based upon the science developed at that time. But again, this is why the rigid general acceptance test isn't really appropriate.
Okay, I know
in
you're
this
on that kick, but let's just focus
Okay.
on contextualizing the need for an expert witness in a case where age could be specifically addressed in a 104 hearing.
If you have a victim who is, say, 15 or 16 years old, and there is evidence that, or let me go in another case. Let's take it another step. If a victim is 3 or 4 years old, the 104 hearing here, I don't think sufficiently addressed whether whether delayed disclosure would be unreliable, or there couldn't be an instruction in that case. Certainly, I don't think it would be appropriate in a case like this, where the victim is 14 or 15 years old, when we don't believe that the science is there backing it up. So, Your Honors, if I understand we're on a tight schedule, if I could also just point out that a task-specific approach under Daubert and Kumo-Tyre is consistent with this Court's earlier holdings on scientific evidence and scientific reliability, starting with the voice print analysis cases of Curiae and N.J.R.E. Those cases, even though Frye was handed down, barely mentioned Frye. I don't think cited Frye. For example, in Curiae, this Court held that there should be testimony that the techniques and equipment used has a sufficient scientific basis to produce reasonably reliable results. Similarly, in N.J.R.E., this Court required reliability to be shown through the proofs offered and the circumstances in the case of that very test. In State v. Cavallo, this case vacillated between the Curiae and N.J.R.E. and the Frye standard, ultimately adopting Frye, but was careful to note that Frye would not be the only method of proving or establishing reliability in criminal cases. Because a defendant in a criminal case's liberty hangs in the balance, a more exacting approach is required in this case. There are no further questions?
Thank you very much.
Thank you, Your Honor.
Mr. N.J.R.E.
Good afternoon, Justices. I come here on behalf of the Association of Criminal Defense Lawyers of New Jersey with this perspective, both of our collective membership and myself, as a practitioner who deals on a daily basis with these issues. And the question I raised in my brief was, and I said, after 3 decades, the question remains, if mental health professionals don't know what CSAAS is, how can we ask jurors to rely upon it? So the argument is twofold. One is CSAAS scientifically reliable? My assignment judge, Judge Bariso, was very clear with regard to that. He said no. He said no. It is not a sufficient science upon which we can allow jurors to rely upon to make these critical decisions. Now, Chief, you mentioned about, in your very first question, had to do about the issue of delayed disclosure. How do we deal with that? Because the experts seem to suggest that that is valid. The only problem with painting it, I think, as a science or social science, it is only one of the 5 factors of CSAAS. So what will we call this? Will we call this the delayed disclosure aspect of CSAAS? The very fact that we make it that convoluted.
Does it really matter what we call it, sir?
I'm sorry?
Does it really matter what we call it? If it exists, the jury gets to determine it?
The problem is in the jury charge, we call it something.
We call it delayed disclosure. How about that?
Has no initials.
Yeah.
Okay. And
Easier to pronounce.
That could work. I'm serious, yes.
Yeah.
But I think we would need to examine and think about whether or not there is enough scientific information by which we can rely on it. Now, the question about do we call the expert to be able to testify to that very limited aspect? I'm afraid of what I call the creeping inclusion of the expert with that kind of information.
Isn't that really what trial judges do every day in evaluating experts having 104 hearings? 702 is the standard, applying the standard that governs the admission of expert testimony in criminal cases, dealing with the individual nuances of the case. Why should we fear creeping something in that very established process?
Here's the example, and it's actually in Judge Stern's WB, where you had the whole colloquy between, it was the recross examination with a 10 to 15%, 5 or 10%. That was a creeping inclusion in the re-examination that veered off into an area nobody knew about. The expert talks of 5 or 10%, just as Albin called it, guilt by statistics. But that was the problem. Here's the practicality, is that the expert report you get generally in these cases, it's 1 page. It's a regurgitation of Summit's article in J.G. It's not like you get an expert testimony, an expert report like you get in a civil case. So that's the problem.
How about a motion of bars in that opinion? Experts are supposed to give you the facts and basis for their opinion. If you get a 1-page report, there's regurgitation. How about a motion to bar that expert?
But see, here's the problem with a net opinion. Remember, you can't testify to the exact facts of this case. You give this generalization. Kids do this, or kids don't disclose, or whatever it is. You can't get into the specific facts of the case.
That's not what a net opinion is. A net opinion gives the basis for the expert's opinion based on the science, based on whatever is relied upon, not on the facts.
Then the expert's opinion would be very, very limited. But as a practitioner, I'm afraid that it gets further, that we can't nail them down. You get the 5 or 10% to argue.
So then don't you object?
You do, but and hopefully the trial judge is going to listen to you. But I think on that
I think
issue,
they usually do, don't they? We have fairly good judges in the state.
Absolutely.
All right.
And I sit on that committee that helps select them, so I know that from personal experience. But I don't know whether or not we get beyond Judge Barisso's finding. He's saying this science is not reliable. Here's the second part, and I think it's the theme that runs through JQ, Justice Lavecchia's decision back in PH, and Judge Stern in WB. What do we tell the jurors about it? What do we tell the jurors? That's the issue that really comes from this. What jury charge do we say? Because we all have to recognize that the issue of credibility of the witness is very important. We have to tell them that. So what's the mechanism by which we do it? Do we do it through expert testimony? I think Judge Barisso's finding says no, we don't. Do we use a general jury charge? Now, here's a dilemma, I think, is that this charge is given in the expert witness section.
Let me pause you, if I may, Mr. N.J.R.E., because where does Judge Barisso say that as to delayed disclosure, there should be no expert testimony? I thought his conclusion was otherwise.
Hey, I believe, but my argument with that is, with due respect to Judge Barisso, is how do you remove the one thing from the...
Okay, but you're not... I think you just said, Judge Barisso said there's no expert testimony in this.
No, on that particular issue, you're right, Justice.
Yeah.
But you've raised a number of legitimate practical concerns that judges need to carefully monitor what evidence comes in, that a charge, if one is afforded, needs to be crafted with care, with the benefit of public comment from the players to weigh in. But the threshold question is whether the science as to delayed disclosure is there. And it seems from the record that there are about 8 studies going back to the Lawson study in 1992 up through the London study in 2008 that suggest it is state-of-the-art, it is reliable. What's the ACDL's position on just that fact?
I think, one, it does not need expert testimony with regard to it. I think it may be in the can of the average juror. And remember,
stay with the reliability problem.
Right. The point I wanted to make was that now this jury charge is given in the expert witness section of the charges. If we were to put this charge in the charge about credibility, we have 9 or 10 or 12 different indicia of what credibility for the quote unquote average witness. If we included in the jury charge on the issue of credibility some specialized, crafted jury charge with regard to this issue.
Aren't you getting way beyond what's before the court? We have a 702 issue here.
Well, if respectfully, if you rule that this is inadmissible, then what's the next step? Where do we go with regard to the issue of reliability, credibility of this particular witness?
What were you going to say about the charge? Were you going to say a charge would be appropriate in the general credibility?
I think that's where you put. I think we have to recognize.
Okay, so on behalf of the ACDL, are you saying that as amicus, friend of the court, you would not be opposed to a charge, some form of charge on delayed disclosure in the general credibility portion of the instructions to the jury?
Yes, without the necessity of expert testimony. I think that recognizes, and that's the beauty of being the amicus, it recognizes that this is an important concern and that the general reliability and credibility of these witnesses needs to be explained in a particular way. So the explanation, we do it regularly, is with a jury charge. And every time when we looked at pH.
What about fresh complaint? Similar, right?
I think that's how we would craft it.
Mm-hmm. Are you saying that there should be no expert testimony allowed and just simply a jury charge?
Yes. Yes.
Is that contrary to Judge Barissa's finding that as to this particular proportion, it's reliable? Should we ignore that? Because you've asked us to adopt Judge Barissa's
as I expressed before, my fear of the expert testimony.
No, let's not talk about fear. Judge Barissa found, in his opinion, that this part of it at least was reliable. Are you suggesting we should ignore that and just not allow expert testimony on it?
I think the jury charge can solve the problem.
What I'm saying is what you want, right?
Yes.
No expert testimony on this section either,
jury
in spite
charge.
of Judge Barissa's 32-page opinion?
As much as I love him, yes, I disagree with that.
Is that why you're here, by the way, because you're from Hudson County?
I think that was probably one of the reasons why. That's why you're the chief judge. You're the perception. I'm going to figure that right out.
You had something you wanted to say about how we followed up with instruction after pH?
Right. Well, actually, you crafted that. I'll call it that one paragraph. Then, of course, Judge Stern then would.
It needed some improvement.
He got rid of the word
right.
He got rid of the word onion.
It's okay.
And I guess. I think that's the care with which we have to do with that charge, because I think the word, forgive me, Justice, I think you used the word stereotype or stereotypical in that particular charge. Now, I know Justice Alvin used the same word when he talked about the dissent with regard to WB. I think we got to be careful of the language, and as the Chief has said, we're not here to craft the jury charge today, right. But I think we have to be careful about the way that we do that. But we do that all the time. The court has the model charge committee. And Justice Patterson, you suggested, of course, that this is really an issue with regard to
702.
A finding with regard to admissibility. But I think we can't ignore that no matter what the court does, there's going to be a jury charge that's got to come out of this exercise that will be all important. My position is that we don't need necessarily expert testimony, but we could do it based on a jury charge, well crafted, that would meet the concerns of all sides.
And you're suggesting something similar to what this court did in Henderson. We had special master, a whole bunch of social scientists and other experts, and the charge now includes some well-recognized social science notions without the need to bring in expert witnesses in every identification case.
The beauty and magic of Henderson Chen was the fact that it sculpted the recognition of what the social science community thought about those things in ever expanding. So in essence, without the need for the expert every time to come in to have a so-called battle of the expert, because the reality is, often I don't think the defendant has the ability often to bring an expert in. So you wind up with this kind of cross-examination. But I think a Henderson-type approach on a jury charge solves our problem, and I think that might even be consistent with what Judge Bariso says.
Henderson says you still get to call the expert if you choose to.
Well, you could have a hearing as to whether or not it would be necessary to do that. That would be a province of the trial court.
What is the criteria for necessary for the trial judge to determine whether you should bring your expert in or not? If you want to bring an expert in and you feel that the expert will help the jury understand the testimony and the facts of the case better, what is the criteria for saying, well, that expert's not necessary?
I think you could have a 104 hearing with regard to whether or not it's within the ken, or whether or not...
Well, let's say it's within the ken, like what Judge Bariso's finding here regarding delayed disclosure. What is the criteria for a judge in a 104 hearing to say, well, your expert may be helpful, you have them available, but it's not necessary for you to call them?
Here's maybe I misspoke and went out too far. If either party could call a witness, right? But it would not be, and I'm trying to think through, the problem with CSAAS is that it is imbued with this specialized, he or she's an expert kind of thing. If you could limit the examination, all right, and there would have to be a real limiting instruction with regard to any expert testimony.
But why are we inventing a new standard as to whether someone can bring in an expert? 702 has the components that deal with all of your concerns. Trial court considers all three prongs of the test.
But the issue would be with the...
under the Frye test. So why are we talking about some special standard that would apply only to this type of evidence?
Maybe it's not a special standard, but I think the expert would not testify to CSAAS, whether we call it by a different name or its testimony.
Shouldn't your emphasis be 403? In this situation, if there were a well-crafted jury charge that gives a fairly good explanation for delay, then the question the trial judge would have to ask, if someone was attempting to proffer expert testimony, is what is it adding? And if it's adding nothing, then it would seem to be within the discretion of the trial judge not to permit the expert testimony.
And that might be, I think my sister made the argument about a 403 issue with regard to whether it is in and of itself prejudicial, because it may be covered already.
From a practical perspective, if counsel knows
it's always
a jury
prejudicial,
charge...
that's what you call it. The 403 says unduly prejudicial.
Unduly prejudicial. I'm sorry, Justice.
You wouldn't call it if it wasn't prejudicial to the other side. You'd leave it home.
From a practical perspective, if counsel knows there's a jury charge at the end of the case, they may choose not to call the expert. And that's likely what we're seeing in the area of eyewitness identification now. But is it the ACDL's position that you could seek to bar, as a matter of law, that expert from testifying in a way that's consistent with the jury charge?
Chief, I got to think about that as I'm standing here. Reverting, I'm dialing this way back. There was once a day that I used to try to call expert witnesses and eyewitness identification. Remember, I'm kind of old at this point, so this was back in the 80s, and I was regularly barred from doing it. In today, I don't have to worry about that. Why? We got a Henderson charge. So I don't know. Maybe the 403 argument would be that you would not need to call that particular witness. If you have it in the charge, if you allow the jury to be thinking about this, recognizing both sides, this is an important issue because we have to decide whether or not the witness is credible or reliable. And that really is the theme that runs through this. What CSAAS really does is attempts to bolster credibility.
Once it's in the charge, one can ask, is it now beyond the ken of the average juror? because that's one of the issues for expert testimony. If a charge is now reducing the issue to a matter that is being explained and therefore is within the ken of the average juror, then the question is, like, what is expert testimony adding?
We'll let you sum up your argument by answering that and take it away.
It doesn't add anything the jury charge in and of itself would be able to satisfy.
Thank
you, Justices.
Ms. Velez, let's give it a try. I think we can get through before break.
Good afternoon. May it please the Court. I will keep this brief. But I think an important framework to remember is that reliability is the linchpin in determining admissibility of evidence under a standard of fairness that is required by the Due Process Clause of the 14th Amendment. Therefore, the admissibility of evidence, particularly putative scientific evidence in a criminal prosecution, implicates important civil liberties concerns each time. Due process requires that our judges serve as gatekeeper, keeping out the unreliable evidence and protection of the constitutional rights of the defendant. To get past the gatekeeper, the proponent of the evidence must clearly establish its reliability. The state failed to clearly establish the reliability of child sexual abuse accommodation syndrome evidence here, and it seems that the court does not want much discussion on Roland Summit's 5-category theory of child sex abuse accommodation syndrome evidence in and of itself, but that certainly does not satisfy Rule 702, as Judge Briseau found, and we take the position that that should certainly be upheld. The second issue that I think that I need to push back against is whether or not this record clearly establishes the conclusion that delayed disclosure is the causal result of the dynamics of child sexual abuse. I don't think that this record does that. This record has a lot of there are a lot of articles in this evidence that speak to transgression, disclosure, research generally, but those articles, that research does not support the position that there is some causal nexus between delayed disclosure and child sex abuse in the first instance.
You're disputing Judge Briseau's finding in that regard. You want us to accept his findings in other aspects, but you want us to reject that particular finding.
Well, I think what Judge Briseau actually finds is that the experts agreed that delayed disclosure does sometimes happen in the child sex abuse accommodation, or in the child sex abuse context, to be clear. And I think the experts did all agree that it does sometimes happen. We're not refuting that. Delayed disclosure can occur and does occur. However, I think
he came to a conclusion under 702 with regard to that.
Well, I think that he was saying that it provides a useful framework for academic conversations about child sex abuse, but not necessarily that delayed disclosure testimony should be admissible under 702.
So you've used the phrase,
Go ahead, please.
Causal result of child sex abuse, which suggests that the delay itself proves the fact that the assault took place. If you remove that from the equation,
right,
is there generally accepted science that's been introduced in this hearing that supports the notion that delay is not all uncommon? Indeed, the science seems to suggest more than that.
So I think the science here suggests that delaying disclosure of a transgression, any wrongdoing generally, is something that is a common reaction of children in response to a transgression.
But the studies specifically refer to child sexual abuse. All the studies that talk about delayed disclosure that are cited deal with child sexual abuse.
So some of the studies actually rebut that assumption, and actually Dr. Lyon's studies that looked at whether or not maltreatment, so not necessarily sex abuse, but whether or not abuse status of a child impacted disclosure behaviors. So one of his studies, this is children's reasoning about disclosing adult transgressions.
That's not what we're talking about.
Oh, I'm sorry?
The studies that talked about delayed disclosure in sexual abuse cases all supported the fact that it's a fairly common occurrence.
That it happens, that's right.
Well, not just it happens, it's fairly common. In one study it was 70-some%, another it was close to 50. I mean, it doesn't just happen, it happens a lot.
And I think that a jury instruction speaking to that might be appropriate. We just think that putting it in the context of child sex abuse without the scientific support for that is maybe premature. And that's not what Judge Briseau was asked to consider here.
What do you think what would be appropriate along these lines? What type of charge?
what type of jury charge, I think that it would be appropriate to say that, based on Dr. Lyons' testimony and Dr. Lyons' research at least, that children sometimes delay disclosure of transgressions generally, and that, that's what the research here supports, or that delayed disclosure sometimes happens in the child sex abuse context, but it's not indicative of whether or not abuse has occurred.
Right. It never was supposed to be diagnostic of whether or not the abuse took place to begin with. It was always about really credibility of the witness, right?
Right. Yes, I agree with that. And I just wanted to go back to the fact that Dr. Lyons' own research, though, just to push back against the assumption that the dynamics of child sex abuse have something to do with disclosure behaviors. He came to the conclusion.
I'm sorry, if you slow down a bit.
Yeah. Sure.
The sentence you just said, if you could say it a little more slowly.
Yes, absolutely. So I do want to go back to Dr. Lyons' own research because he looks generally at transgressions and disclosure behaviors among children. And one of the conclusions that he came to is that maltreatment status of a child, meaning whether or not they had experienced abuse, had no impact on the disclosure behaviors that the child was exhibiting. So I think that the assumption, basically, that this record supports that there's a connection between child sex abuse and disclosure behaviors just isn't here. I'm not saying that that wouldn't be scientifically reliable.
That's different than credibility. I don't know that anyone's even arguing, because there's delayed reporting, therefore the defendant is more likely to be guilty. The question comes down to credibility, whether or not a child should be disbelieved merely because the child delayed reporting.
And I agree with you, Justice Albin, and I think something like a fresh complaint instruction that would say, you shouldn't discredit the child simply because there was a delay, that might be appropriate. I think that the instruction that was proposed by the public defender, something like that would be appropriate here. And I think, the biggest takeaway is just that this question was limited to whether or not child sex abuse accommodation syndrome is scientifically reliable. The record here clearly establishes that that's not the case.
And your position is, or your client's position is that that to the extent that Judge Barisso's findings support the admissibility under the second prong of Kelly and Harvey and the Frye test and Rule 702, the admission of testimony of the delayed disclosure phenomenon, I'm not talking about a syndrome, but the fact that it occurs, you are saying we should reject that.
I don't know that there should be testimony as to delayed disclosure, expert testimony. I think that a jury instruction would be the better way to do it because then we're within the count of the average juror, I believe.
Questions?
Thank you. Thank you.
Let's take a recess.
May it please the Court. Child sexual abuse accommodation syndrome, commonly referred to as CSAAS, tells the story of suffering and survival, silence and shame, helplessness and horror. Most victims of child sexual abuse are sexually abused by someone that they know, love, and trust. Like battered women syndrome, CSAAS testimony helps dispel juror misconceptions about a child's credibility or truthfulness. CSAAS testimony does not and cannot be offered to prove sexual abuse, nor does it provide a clinical diagnosis of the abuse. CSAAS testimony seeks only to offer a possible explanation of a child's behavior that may seem inconsistent with sexual abuse. In an area where jurors expect violence and not seduction, CSAAS is critical to explaining the dynamics of child sexual abuse. There is substantial scientific support for expert testimony on CSAAS, specifically delay, denial, and recantation. And the studies have shown that there's strong empirical support for CSAAS. And when I talk about studies, in the court below, so much of
so much of what was talked about was a meta-analysis. This is a meta-analysis. So just looking at it at its core, what is a meta-analysis? It's a statistical review of a number of different studies with different criteria to arrive at some sort of conclusion. And specifically, Justices, when I'm talking about the strong empirical support, I'm talking about population surveys with adults. So this is when we ask adults about abuse that they may have experienced as children. Child interviewing studies. These are when children are first questioned and then subsequently questioned. Thirdly, experimental work on children's disclosure of transgressions. And fourthly, researchers, and this was just Dr. Lyon who said he did this, and this is questioning perpetrators about their modus operandi. So, Justices, the power and the status difference between adult offenders and children they victimize make the overt use of force generally unnecessary. And so these are all of the ways in which the state would submit to your honors that we did establish that CSAAS has scientific foundation. Under State versus Harvey, your honors, the state does not have to demonstrate that the techniques, the methodology, and the procedures are infallible. In fact, the acceptance need not even be unanimous. So you all, Justices, have the record in front of you. And the record of this Fry hearing shows us just how different the approach is. Judge Bariso focused entirely, almost to a fault, I would say, about the definitions, right? The experts can't agree about definitions. But the two experts that really are the experts in this area, and I would say Dr. Lyon, because not only is he conducting research on children, he's also in a position where he's tested these hypotheses. He's cataloged these studies, he's reviewed them, and he's looked at the statistics. And then we heard from someone like Dr. Brainerd. And Dr. Brainerd is an exceptional mind in the area that he's in. But his area of hypothesis are scientific type studies that deal with, for instance, this is not a drug or a medication where you're going to have one group of people that are given a placebo and then another set that is actually given the drug, and then you measure the results. This isn't that type of area. So when we look at Dr. Brainerd, and one of the things that Dr. Brainerd and Judge Bariso seemed to focus on was this notion of, is it reliable and is it replicable? Is it reliable? And the state submits to you it is reliable. We have a host of studies that tell us that delayed disclosure exists. And I want to go through some of the testimony from Dr. Bruck. And this isn't the state's experts. This isn't my expert. This is the defense's expert. And Dr. Bruck, so London and Bruck do these two reviews. And their reviews, again, are the same reviews that everyone else does. With the exception of the body diagrams, Dr. Bruck's focus is on suggestibility. Jeopardy in the courtroom, all of that deals with suggestibility. But these are the kinds of things that Dr. Bruck said. And I would turn the court's attention to 15T, that's the transcript from the Fry hearing of Dr. Bruck's testimony. And she says, kids don't run up and tell what happened. That's at pages 41 and 47. Dr. Bruck again, page 45. There's some people who keep this as a lifelong secret. That's page 45. There are circumstances in which abused kids shut down, don't disclose, deny, and recant. That's page 62 of that 15T transcript. And then she says, children as young as 3 will lie to avoid punishment. That's page 104. Children will lie to keep adults out of trouble. Page 105. African American, Puerto Rican, and Latina girls are less likely to tell. Page 122. Physical findings of child sexual abuse appear in less than 1 to 3% of cases. That's the defense's expert agreeing with the state.
So where is the scientific consensus on the reliability? I mean,
Well-
you're talking about individual findings by individual people, and that's not Fry. Fry is looking for reliability and consensus among the people who are analyzing these things.
Your Honor-
And Judge Barriso did not find it.
Yes. Judge, what I would say is just looking at that, you're saying where is the consensus? So the consensus, we have consensus on denial, delay, and recantation. And when we talk about consensus, these are not studies that deal with children that are all the same age. Because think about this. In order to conduct these studies, all of the children would have to be 5 years old. They'd all have to be in a household where they were either abused by the same individual. The length of the abuse would have to be the same. The number of siblings that they had would have to have been the same. And the type of abuse that they suffered would have to have been the same.
Ms. Rana,
Yes, yes, Chief Justice.
you said that 3 of the factors have scientific support, and I'll come back to that in a second.
Yes, sir.
Are you conceding that the other 2 do not?
No, Judge, no, Justice.
So let's break those down.
Apologies.
Helplessness.
So the reason that
May I ask a question?
Of course.
Helplessness doesn't appear to be a scientific finding at all. It's just a description of something that exists. Accommodation, based on the testimony at the hearing, seems to cover the entire spectrum. Good behavior, bad behavior, and everything in between. How is that reliable? It seems as though it proves both too much and nothing at all at the same time.
Chief Justice, helplessness and accommodation are both constructs that lead to the secrecy. They lead to the delay in disclosure. They lead to the denial. They lead to possible recantation. So the reason that I'm not conceding that those items don't exist is that those aren't 2 constructs or factors that are necessarily measurable.
How does accommodation lead to those other factors?
So a child who's in a situation, for instance, in J.L.G. In J.L.G., part of what my adversaries and opponents said here was, well, the victim was 16 years old. We forget that the victim in that case was 3 months old when that defendant, when J.L.G. came into the home. He was the only father that she knew. Accommodation happens because the child then adjusts to the behavior. The child begins to accept the sexual abuse. So over the course of, in that particular case, you'll recall that in J.L.G., the abuse starts at age 14. So this is someone who used to braid her hair, I think, is what she testified to. It was someone that had always been a father figure for her. And in order for that particular victim to survive, to sort of deal with what was going on and the dynamics of the person who had a lot of power in that home because he was the stay-at-home parent, she began to accommodate.
Does it sound like science from a layperson or an expert's perspective?
It sounds like social science.
To say that any behavior of any sort could stem and be associated with child sex abuse?
Well, Your Honor, we're not saying that it's any behavior, and I would analogize to the battered woman syndrome. Because in the battered woman syndrome, you'll recall that Dr. Lenore Walker talked about the fact that in battered women syndrome, there were 3 distinct and repetitive stages. However, she talked about the fact that the duration and the intensity depended upon the individuals involved. So that didn't mean that jurors don't hear about battered women syndrome, even though we know that there are these various stages, that there are at least 3 stages. And even in that case, Your Honor, my recollection is in looking at State v. Kelly and State v. Townsend, that at that point, the court did notice that judicial opinions were split on the scientific acceptability of the syndrome. And here, Your Honor, perhaps syndrome is the misnomer because the state's experts did say and did concede that maybe a pattern of abuse or construct or generalized behaviors may have been a better description to talk about what some children who experience child sexual abuse how they behave and how they react.
Helplessness doesn't even seem to fit the category of behavior. It seems more like a subjective state, as I think was pointed out by one of the amici. So how do we even include that as a behavior that's been empirically supported?
Well, Justice LaVecchia, when we think about helplessness in the CSAAS context, it's not really any different than in BWS. It's learned helplessness. The child, again, we're talking about the dynamics between the child and the parent. So routinely, children are told to do as they're instructed, do what the nanny tells you, follow what your coach says. So that's a concept that I think isn't unique to CSAAS.
How is it helpful?
It's emphasized here, though.
But how is it helpful?
It's helpful because it explains why didn't she tell. She was one of the arguments I heard was, well, we're talking about a post-pubescent versus a pubescent person. You know, this child, the victim, and I'm going to use the names that the appellate division used, that Bonnie was 16. And the abuse started at 14. But helplessness started from the moment that she was entrusted in the care of this individual who then decided to exploit the trust that she had in the person that she considered her father.
CSAAS puts this helplessness in a separate category. But if you read the content of the expert testimony, helplessness is simply a factor in explaining behavior. Helplessness is not a behavior. It is a factor used to explain the behavior.
Yes, Justice Patterson. So helplessness and accommodation are factors that explain the behaviors of delayed disclosure, of denial, and recantation. Because as adults, when we look at this, we think, how is it possible that in J.L.G., and I want to address this specifically because I believe it was Justice Alban who asked, well, why did they even need CSAAS here? And part of the issue there, as you all may recall from the record, the appellate division says that it happened in early June 2012, that the mother's best friend walks in and sees some sort of behavior going on that he terms as inappropriate and horseplay. But if you look at the trial transcript, and I didn't try the case below, but if you look at the trial transcript, the best friend walks in, or he says it sometime in 2011. So if you're a juror hearing that testimony, the first question that you have is, Bonnie had the opportunity to tell. Somebody walked in and saw something, and she still didn't tell. And why didn't she tell? Because she was fabricating it. Because she was bristling as a teenager against some sort of imagined strict rules that the stepfather had now put in place for her. And so that's why in that particular case, CSAAS was necessary. Because for most lay people, you listen to that story and think, that's your opportunity to jump up and down and say, oh my God, this person, you're not going to believe what he's been doing to me.
So the question isn't, is it necessary? The first question has to be, is it reliable? Is it sufficiently grounded in state-of-the-art evidence? Take recantation. I believe Dr. Urso, your expert, said it's perhaps the most debated of the behaviors. What is it that you rely upon to suggest that the science supports recantation?
Chief Justice, we recognize that recantation is controversial, and what the state is relying upon are a number of studies that show that. So look at one of the things that I would direct your attentions to is the Malloy and Lyon study. So Dr. Lindsay Malloy and Dr. Lyon look at children, and they look at a study that consisted only of substantiated claims of child sexual abuse. And there they found a 23% rate. And Justice, most importantly, and I think one of the disappointments is that the Fry opinion, Judge Bariso's opinion, is completely silent regarding the independent discovery of abuse by diagnosis of STDs or videos. And I really want to focus on that. So that's one of the things that I want to focus on.
So you mentioned Malloy. That's less than 1 1/4.
25%.
And Is that the strong evidence of scientific support for recantation?
Sure, because what that tells us is that at least 25 to 23% of these victims are recanting. And when we think about the number of cases that actually go to trial, that statistic represents a child who may have recanted. I also want to highlight to the court the recantation rate in the 1996 Gordon and J.L.G study. This is Paula Gordon's study, Your Honors. And here it's 14 children with STDs, and only 6 of those children disclosed sexual abuse. Out of that 6, 3 recanted. So the recantation rate there is 50%. We're talking about an independent, objective finding that there's been some sort of sexual contact.
So we don't look for unanimity, but we do look for general support in the relevant scientific community. You have the McGuire study, the J.L.G study, the London study, which speak to recantation being extremely rare, being the exception, being only a minority, a relatively low rate. When you look at all of this body of evidence, how can the state come forward, including its own expert, and say there's general support in the scientific community for this particular principle?
One of the reasons is, Your Honor, if you consider the definition of recantation. So when Drs. Bruck and London did their study, they had this tortured, twisted definition of recantation. It only counted as recantation if it was to the same trial team. And the reality of this case is, for those of us that try these cases, because I tell the guidance counselor that this happened, and now the guidance counselor has to get DCP and P involved, and then there's a formalized interview, if the first time I say in the formalized interview that this didn't happen, that doesn't count as a recantation under Bruck and London study because it wasn't to the same trial team. So the state is looking at the ordinary definition of recantation, to take something back. As Your Honors are aware, when we talk about fresh complaint witness testimony, when we talk about the series of steps that are taken for a child sexual abuse case to actually get to trial. So the child, let's talk about this case, Bonnie. Bonnie makes the disclosure to her mother. Her mother then calls the hospital and takes her to the hospital or takes her to wherever. She's then interviewed by the local police department, and then the protocol is that she goes to the Hudson County Prosecutor's Office, the Special Victims Unit. Under the Bruck and London test of recantation, under their limited definition of recantation, if she never recants to the same treatment team, if she doesn't recant to the same detectives who interviewed her at HCPO, SVU, then it's not a recantation. Well, what about the fact that she had an opportunity when Mom came home and the best friend was there to say, is something happening? Mom had a knife in her hands and was jumping up and down and says to Bonnie, what's going on? Because if he's doing something to you, I'm going to effing kill him.
Let's come back to the syndrome.
Yes.
There's no doubt that some victims of child sex abuse recant even though their report was truthful. And that's an argument that has been advanced by you and the Attorney General. Do you dispute that some victims recant because they've lied originally?
Your Honors, I don't dispute that, and that's part of what's interesting about...
So given that, your position is that you're entitled to call an expert to explain it in the context that is favorable to you. Does the defense also get to call an expert for the opposite?
The defense routinely on cases, whether it's a DNA case, whether it's an identification case, has the ability to call an expert. And in fact...
That's not what's happening with CSAAS.
Well, the defense can not only cross-examine, and we saw that in J.L.G. Dr. Tasca was cross-examined regarding Drs. London and Bruck's papers, the 2005 paper as well.
You're not equating cross-examination of adverse expert to direct examination of your own expert. You're not saying they're both one and the same, are you?
No, Your Honor. I'm not suggesting that they're one and the same, but the defendant always has the right to put forth their own expert that is going to dispute the science of recantation.
So you gave us a 25% number. So is that in 25% of the recantations, the victim, in fact, was recanting something that was, in fact, truthful, right?
It's actually...
So that gives us a 75% number. And this is pivoting off of the Chief. If we're playing statistics, could the defense put an expert witness on and say, like 75% of these cases, the recantation is valid? What would you say to that?
Well, Your Honors, I would say first, it's at least the Malloy study was 23%. But more importantly, in State versus WB, we're not putting forth statistics to the jury. And in fact, the expert that comes in and testifies, they know nothing about the case. So that expert is not saying, take these behaviors as proof that Bonnie was abused. And I think that's part of what got lost in the Fry hearing. Proof of abuse versus rehabilitative or educational testimony. And one of the highlights of that is when we see Judge Bariso quoting a portion of Dr. Lyons' testimony, and he says, well, even Dr. Lyons says that that these behaviors don't just appear in children that are sexually abused. Well, you'd never be asking a child that was not sexually abused of why they delayed. Because if there's no abuse, it would be crazy to compare someone who'd never been abused with someone who's abused.
But you want to put an expert on, with respect to recantation to say that untruthful recantations are somewhat common. Can the defense now put on truthful recantations are really common in this area, according to your own studies?
Certainly there's no bar to that. I mean, part of what
And how is that going to advance the truth-seeking function of these trials?
Well, let's take the example of DNA. So DNA was given as an example here. Here there was, I believe there were the shorts of Bonnie that were taken. So the major contributor to the DNA in those shorts was Bonnie. Bonnie skin cells, it's Bonnie shorts. There was a minor contributor, but all they could find was Y.S.T.R. DNA, which your honors are all familiar with. That's the male DNA. So they didn't develop a full profile, and all they heard was that the defendant could not be excluded because the Y.S.T.R., meaning all of his male relatives, would have those particular alleles. But routinely, I've had DNA experts come in for the defense and challenge that what such DNA is, the fact that DNA can be transferred from an object to an individual. And one example I'll give you that's specific to the child sex abuse cases is the notion that if it's a familial or intrafamilial case, what's happened is that the family's using the same hamper. So the argument tends to be, yes, dad's shorts are going in the hamper and victim's shirt is going into the hamper, and you, ladies and gentlemen of the jury, can't take anything from the DNA that they brought before you because there can be a transfer of DNA, specifically spermatozoa or something else, onto clothing.
I thought, but in this case, unless I've got these statistics wrong that you have presented to us, you're saying to us that truthful recantations are in a much greater number than the untruthful ones, according to your own statistics.
Well, we don't, and here's what's interesting about that.
Am I off about that?
Your Honors, you're not, Justice, you're not off about that. But what I'm saying is when we look at the study and the systematic review of the study, the real danger in coming up and saying, well, 75% of those recantations were truthful. We actually don't know that because we don't know how old the children were. We don't know how recantation was defined. We don't know how the children were questioned, and we don't know whether the recantation dealt with a specific type of sexual abuse, meaning molestation versus penetration, vaginal penetration versus anal penetration. So the danger in sort of lumping all of these studies together, and that's what Breck and London did, right? They looked at these meta-analyses and said, oh, here are what the statistics show us.
Would you clarify one thing for me?
Yes,
I thought the 25, it was actually, I think, 23% recantation rate was the number of percentage of sexually abused victims who recanted, not the percentage of truthful recantations. Am I wrong?
It was the number. My understanding from Dr. Malloy and Dr. Lyon's study is that that was the number of cases where sexual abuse had been substantiated, and 23% of those children still recanted.
So that's how I understood it as well.
Yes.
Which begs the follow-up question. Does that support the notion that recantation is something that takes place in a majority of these cases? Or is it a more uncommon occurrence?
One of the things that I want to stress is when CSAAS testimony is before the jury, you'll never hear, at least in Dr. Haska's testimony, and I have the trial testimony with me, that she doesn't say recantation happens in the majority of cases. In fact, what we often say is, some children recant. And I want to go back to Dr. Bruck, where she said on page 190, children, and this is again 15T of the transcript, where she says children sometimes recant. She also admitted that there are no studies where there's 0% delay in disclosure or 0% recantation. Your Honors, whether the child is facing removal from the home, and that's the Malloy study, Chief Justice Rabner, that you referred to, that impacts recantation, age, gender, and closeness of the relationship with the perpetrator. So we're talking about all of these factors, and I'm being asked, or we're asking our experts to come up with one specific statistic. And so the difficulty in that is you're talking about children from different ethnic groups, different age groups, and different types of abuse. So I just want to highlight the fact that what the state is saying is when you look at more generalized experiments where children don't tell. And this is why this is valuable. There was I don't know whether aspersions were cast in the hearing, or perhaps I was sensitive and thought I was hearing aspersions, but I want to talk about why children, what these general transgression experiments tell us. And you all have the Pipe and Goodman study. So the Pipe and Goodman study tell us that this is the study where adults spill ink on the gloves of children. And 42% so this is a specific group, this is a controlled study, 42% of 5-year-old kids claim they didn't know who had spilled the ink. 25% of that group maintained that ignorance almost 2 months later. Similarly, when I look at Dr. Lyon's study, and Dr. Lyon, I would submit, is a nationally recognized expert in this area. And just in terms of Dr. Lyon, he had never testified before. Not for the state, not for the defense. This is someone who really came in and for the first time had no bias and talked about all of the studies. So Dr. Lyon does the study. And again, it's children ages 4 to 9. And these kids are playing with a toy with a friendly stranger. And at some point, the toy breaks. And the stranger says to the child, "Don't tell because we could get in trouble." And then ask the child to keep it a secret. And in that particular study, this is 13T of the record, page 111, lines 5 to 13, 70% of the children kept the secret. And this is somebody who's a stranger. This isn't someone who's a family member. This isn't someone who's a coach. This isn't someone who's a teacher. I also want to direct the court's attention to the Clark and Stewart study. You might recall that study. This is Chester. I think he's either the maintenance man or the janitor who comes in, and so he starts playing with dolls. And he tells the children that he would lose his job if the boss had learned that he had played with the dolls. And in that particular case, and this comes from Brecht's study, this is Drs. London and Brecht talking about this, 69% of the children kept the secret when they were interviewed by a neutral interviewer. And the last, or one of the last studies I want to talk about is the Barbie doll study. And the Barbie doll study is important because the Barbie doll study is with a family member. So in the Barbie doll study, and I don't know if it was girls or boys, I just know that there were children who were 3 to 5 years old, and they broke a Barbie doll with their parents. So actually it was specifically mothers. So when the mothers of 3 to 5 year olds said, the mothers broke the Barbie doll and they said, don't say anything, only 1 in 49 children mentioned to an interview what had actually happened. So that's a parent in a fairly innocuous situation that doesn't have the stigma or the shame of being violated in the way that a child would be violated in a child sexual assault or abuse case.
You've done a terrific job both in writing and today in summarizing the studies. And I think, is it fair to say that what these studies do is show that, obviously there are varying percentages, but substantial percentages of children behave in a particular way, either maintaining the secrecy of what an adult tells them to do, or denying that they know something that they know. Is that a fair assumption of what that is?
Yes, Your Honor.
Okay. Now, what is the expert testimony presented at the hearing that gives rise to CSAAS as a syndrome to be presented, not as a for example, a DSM diagnosis of the defendant as behaving as exhibiting certain characteristics or symptoms, but a syndrome that is potentially indicative, in some cases, of child sexual abuse. Do you see the distinction? We have, really interesting data on how children behave in certain circumstances. What we have in CSAAS is the presentation to the jury of a 5-part syndrome as if it is a diagnostic methodology.
Justice Patterson, the jury charge for CSAAS explicitly says that it's not diagnostic. It explicitly says that, and I just want to touch on the fact that the witnesses. Let me
pause you there, because I just want to drill down a little bit about that. Okay, I understand, and I am familiar with the charge, but we're talking about how the data that was presented, that was obviously the older data, resulted in CSAAS, found its way into an expert testimony before juries reporting on a syndrome. The syndrome suggests, I think this is a fair summary of it, that these things fit together to prove something. And that is, just to be frank with you, in terms of my own view of what the testimony showed, really not dealt with very much by the experts. You can certainly report on studies, and you can come to the conclusion, if those studies were separately presented to you as a fact finder, that this is a phenomenon that is indicative of that is characteristic of some children. But where do we get the 5-part syndrome out of the studies?
So the syndrome, and it's a misnomer. I think even
it's the S of CSAAS.
Well,
is it not?
It is, and even Dr. Summit himself, after the 83 paper and the 92 paper, says, if I had known that there was going to be this use of it to be diagnostic, I probably wouldn't have called it a syndrome. I would have called it behaviors. One of the things that this reminds me of is the State versus Townsend case, and you'll recall that in State versus Townsend, in that case, the state is introducing battered woman syndrome, and they're introducing it for the decedent. So the decedent had never been diagnosed as having suffered from battered woman syndrome, but the court permitted the testimony to show, again, that it was a cluster of behaviors that the decedent or that the victim could have been suffering from, and that's why this dying declaration was, no, my husband didn't do this to me.
And I understand the comparison there, but obviously when you have a 702 hearing, you look at the evidence before you in and of itself. You don't compare it with some other decision that was made on something that is arguably similar or maybe different. So where is the data that brings all of these studies and allows an expert to testify to the jury about a 5-part syndrome?
Justice Patterson, I would say that all of these studies taken together paint a picture. They cover the mosaic of this behavior. So I wish that I could say to you, Dr. Lyon's X study says that it's a syndrome. I would say that Drs. Malloy and Lyon support CSAAS.
If you were starting with as obviously extremely well versed in this as an attorney, and you were going to essentially redo this on a clean slate, how would you, with bearing in mind the requirements of 702, how would you present it?
Yes, Your Honor. Well, looking at Rule 702, Judge, first Justice, pardon me.
No problem.
I want to address this notion that it's beyond the ken of the jury. So it is certainly beyond the ken of the jury.
Sorry, my question wasn't clear. What I'm saying is, if you were to present this and work with an expert and present it, would you present this as 5 individual, or really two behaviors that the 2 conditions that the children may be in that explain behaviors, and 3 behaviors as separate phenomena, correct?
Understood.
Yeah.
So the questioning to the expert in direct examination would be, what are the behaviors? Expert Dr. X, you know nothing about this case. So what are the behaviors that some children who have been sexually abused manifest? And the doctor would say, there's a delayed disclosure, sometimes there's a recantation, and denial is fairly common. Doctor, what causes that? Or what's your understanding of what may cause a child to delay disclosing? And the doctor could explain the generalized concepts of helplessness, the generalized concept of accommodation.
Along with other factors as well. But the actual opinion would focus on the 3 that you talked about.
Yes, Your Honor.
Suppose the court were to narrow it just to delayed disclosure. You heard the back and forth earlier in the day with the other side of the aisle. Could the state present an expert with regard to that in all cases?
Your Honor, clearly it would depend on the facts of the case, but the danger in limiting it to just delayed disclosure is that it doesn't explain denial and recantation. So delayed disclosure just simply would mean silence. Would delayed disclosure capture the fact that Bonnie didn't tell when the best friend called her mom and mom came to the house? Is that a delayed disclosure, or is that a denial? Or is that a recantation because she said nothing's happening?
Well, it's probably not a recantation.
Because she didn't disclose.
In many of these cases, put aside the expert witnesses, does the testimony of the victim, relative, or some other person explain the delay, the recantation, the denial? For instance, in this case, you have the victim on the stand saying that she didn't tell her mother the truth because she didn't want her, being the mother, to do anything illegal for her to get locked up. That was her testimony, right?
Yes.
And that was an explanation for why she did not come forward earlier, correct?
Yes, Your Honor.
Without any expert testimony. Very rational, solid reason that the jury could accept. Maybe deny, but certainly accept.
Certainly that occurred there, Justice Alvin, but not all children, as the courts have recognized, have the verbal or the cognitive skills to be able to offer an explanation.
So I get that. So yes. Okay. So, but in the cases where there are explanations, given by the victim and others to account for these behaviors, is it necessary or appropriate to have expert testimony?
Again, it would depend on the totality.
Let's take this case. We have a case before us. The victim gets on the stand and gives a direct explanation as to why she delayed. Like, why do I need an expert witness to explain now why she delayed when she explained why she delayed?
Well, the expert witness also talked about the silence and the fact that there was an extended period of silence.
Forgive me. That's why I asked my question earlier as I did. I want you to assume, for purposes of responding to Justice Albin's question, that the court might not adopt your full argument and only permit expert testimony on delayed disclosure. In a case such as this, where the victim comes forward with explanations that appear to be easy for a layperson to understand, is it appropriate for the expert testimony to be introduced?
I believe it is appropriate, and part of the reason is, as a practitioner, we're saying, oh, it's easy for the jury to understand, but in the same way that jurors may understand that portion of it, they generally know DNA exists. That doesn't mean that we don't call a DNA expert or that they don't get to hear DNA testimony.
Would that be sorted out on a case-by-case basis by a judge in a 104 hearing?
Certainly. I mean, certainly as the gatekeeper, courts could have a 104 hearing. But I would say when we talk about the science of all of this, and I just want to return to the science of this for a moment, and that it's an explanation that jurors may be able to understand. The defense demanded science, but then Dr. Bruck cited a study, a Midwestern college study, that talked about how most of those college students could understand delay, yet those same college students, about 70% of those college students expected that there would be physical signs of abuse. And so we're talking about a very obviously complex, taboo, difficult area to understand. If we've learned anything from the Me Too movement, if we've learned anything from all of the abuses that have been suffered by some of our Olympians, these gymnastic Olympians, the idea is that people who had more resources than anyone, just looking at the Me Too movement, women that are powerful, that are well known, that have more resources than anyone, didn't come forward, and yet we're expecting children to come forward and then immediately disclose every portion of whatever has been done to them over the course of however long the abuse happened. And one other thing I would add is when we talk about battered women syndrome, and as someone who's tried these domestic violence cases, one of the difficulties in expressing to a jury is, why did she go back? Clearly she doesn't care. It couldn't have been that bad because she went back. Why would she continue to go back? And yes, the victim there is an adult, and she's able to explain her financial dependence on the abuser. So in this particular case, even in those cases, when you're dealing with adults, jurors have natural questions regarding the credibility of what the victim is saying based on the fact that the victim remains. We're certainly not going to be asking 6-year-olds to move out of the house because they're completely dependent upon these adults.
I take it, well, you've argued, there's a statistically significant number of victims who deny, delay, recant. We know those three. And you have another explanation. There's an explanation that experts have given as to why they do that. Helplessness and accommodation. Is it necessary that in fact the case involved, and the CASLIS is going in a completely different direction, but is it necessary to have those specific characteristics in a particular case in order to call an expert to explain that that characteristic is not uncommon? It happens in 20 or 30% of the cases of child sexual abuse. Is that what would be required? In other words, apply behaviors to what is commonly found in incidents of child sexual abuse? And if so, that's the statistical number. Would you need to have an expert actually examine the victim and try to explain why that victim acted in that way in accordance with what is to be expected, in accordance with what's to be expected? Do you get that?
I do, Justice Solomon, and the reason that we don't have experts examine the victim and then say, yes, this child is suffering.
No, not yes. I'm not talking about physical evidence of abuse. I'm talking about an explanation that, can you simply, based on statistics, talk about the why it happened? Don't you need something more than that? I understand that it happened because it happens, it's common. Statistically significant numbers do deny, delay, recant. But can you give why testimony without something more than a statistical analysis?
Yeah, so the danger for us, when we're talking about behavioral examinations, the expert can't come in and say, because it's the ultimate fact for the jury to find, if the expert says, these are behaviors, I examined Bonnie here. I examined her over the course of 3 therapeutic sessions. And in those 3 therapeutic sessions, I found that she was suffering from anxiety, from depression, and she exhibited signs of child sexual abuse. That's not permitted. We're not able to do that. And one of the reasons, again,
is... So why should you be permitted to say that these things occurred because, it was a familial relationship? It was just that there is a period of helplessness, there's a period of accommodation. Why should you be able to say that?
Currently, the way that this testimony is presented, and the jury charge makes very clear to jurors that they're able to accept some, reject all, specifically says that this expert is not here to say that the child actually suffered. They're just giving you some commonly...
I understand that.
Right, but it's sort of like PTSD.
I'm asking you the ultimate... Yeah, but there you... Okay, that's different. But there, you're asking in part... I understand that there is a statistically significant number that deny, delay, recant. This is the number. It's not uncommon in these kinds of cases. Done. We're not talking about this particular case. But now when you say why they do that and explain why in sexual assault cases, not this one, generally they do it, can you make that connection in this way, using this testimony, without something more?
I think the expert has to be able to talk about familial dynamics and has to be able to talk about the power dynamics that lead to helplessness and accommodation.
Is there a statistical analysis of how many times that occurs? For example, in 70% of delayed responses, it was because there was a familial relationship, or there was a familial relationship. In 80% of recantations, it was because, etc. Is there a way to do that? Is there any statistical information on that?
So the Malloy studies tell us that age, gender, and closeness, or the familial relationship with the perpetrator, they impact recantation. So the closer the familial relationship, the higher the chance of recantation. Gender also impacts it. Boys tend to disclose lesser and fewer numbers than girls. Age as well. Older children may tell more quickly than someone who's younger. I think one of the studies indicated that older children tell deliberately and younger children tell spontaneously. And I can't recall right now, but I think I also want to just stress that when we look at the Lawson and Chafin studies, and that's a study that basically everyone agrees on, even Dr. Bruck says that's one of the better studies, that these are studies that specifically show us that more than half of the children deny being abused. The Lawson and Chafin study is the 92 study. 57% of the children deny being abused. And I think I neglected to talk about the Swedish study, so I don't want to sit down without talking about it, but you all may recall that the Solberg study, and that's the case where they actually had, that's an amazing case because they have the same perpetrator on video. Same perpetrator, sexually abusing children. And in that particular study, this is the Sochberg and Lindblad study, and I think I'm butchering the Swedish name, but it's a video of children being abused. But in that study, and this is a 2002 study, only 50% of those kids, only 50% of those children admit abuse. And yet we have an independent, objective, for lack of a better word, eyewitness. We have video that shows the abuse actually happening.
Let me ask you to try to wrap up your argument, please.
Yes, Your Honor. Justice, clearly I feel strongly about this area of the law. And what I would say to you, that the studies show us that there's strong empirical support for CSAAS. The population surveys with adults that I've talked about, the child interviewing studies, the experimental work on children's disclosures, and the research questioning perpetrators. And Your Honor, one of the things that I would certainly stress is whether it's 25% or 10% or 20%. That statistic represents a child that's been violated. That statistic represents a child who's come forward, and they've come forward despite the stigma, despite the shame, despite perhaps being taken out of their home and being placed in a foster setting. And one of the things, and this is Dr. Bruck's review, one of the things Dr. Bruck finds is that Latina, Puerto Rican, and African American girls are even less likely to come forward, and they're more likely to recant because of all of the familial pressures based on what the family relationship and what the structure is in the home. So when you have these extended families living together, the pressures on children are real. This is not the hysteria of the 80s. And that's sort of what Dr. Bruck talked about. So much of her testimony in the Fry hearing was about all of the studies that have been discredited. And the state doesn't want innocent people being falsely accused of sex assault. But those were very specific, discrete cases. We're talking about Michael's, right, the daycare case. We're talking about ritualistic satanic abuse. 35 years from, we've come so far from that. When we look at all of the advancements that have been made since Dr. Summit's initial paper, we're in so much of a better place, and the studies are in a better place to tell us that the delay, denial, and recantation happen. Thank you.
Ms. Elsasser.
Good afternoon, Your Honors. May it please the Court. There is no debate that delayed disclosure, denial, recantation exist. In fact, at the hearing below, the experts agreed that some children may delay disclosing sexual abuse, and some children may deny or recant abuse. What there is disagreement over, however, are statistics, the statistical percentages, as to the frequency of these components. But those statistical percentages do not matter, because CSAAS testimony is not being introduced to prove that a particular child was in fact abused, or that a particular offendant did in fact commit these crimes against the child. So in sum, it is not scientifically supportable to use CSAAS to prove that abuse occurs. But what we see at the hearing below, it is in fact scientifically supportable to use CSAAS to explain to a jury how abuse occurs and how it may lead to disclosure characteristics that might seem unusual. Now, one thing I do want to jump to, just because we didn't talk about it during the state's presentation, is the jury instruction, and whether or not a jury's instruction would suffice in this instance. And it would be the AG's position that it wouldn't, and it wouldn't for several reasons. First, even if we do have a jury instruction, that still doesn't prohibit the state from under 702 to be able to call their own witness, which I believe, Chief Justice, you did recognize was part of Henderson. Henderson does introduce the scurry instruction, but that still doesn't take away anyone's right to call an expert. Two, a jury instruction wouldn't suffice because this is something that we believe is firmly outside the ken of the average juror. Again, I'll bring in Henderson here. This is unlike Henderson because dealing with things of eyewitness identification and identification generally, most jurors can understand that I can see something better in the daylight than I can see at nighttime. So when that's put to a jury instruction, it makes a little more sense because that's something that's firmly within their ken, their understanding. But when we're talking about children who have been abused for over a period of 10 years and why they keep that a secret and why they do not disclose that to an adult, that is something, again, that the AG believes is firmly outside of the ken of the average juror.
And just while we're on that point,
sure.
When in general, when that first prong of the test is applied, we're not talking about the place where the jury will be after a trial of a week or 3 or 4 weeks. We're talking about the jury's day-to-day life, not after they've been educated by the judge or by the testimony in the trial. Am I correct?
The myths, the misconceptions, the biases they might have when they walk in through the front door. And yes, it is true that today, as opposed to, a decade ago even, or 2 decades ago, it's certainly more prevalent in the news nowadays. But for us to assume that really has any impact on juror biases, I mean, we would have to, number one, make sure that all of our jurors, our potential jurors, are even paying attention to this news, which we can't really guarantee, or that when they are paying attention to these news articles that they read on CNN or otherwise, that they're truly understanding the full dynamics of what a child is going through when they're preparing to disclose or when they're succumbing to this abuse.
So, I've read multiple transcripts of CSAAS testimony, and since they're not individualized, it's the same script over and over again. So that's why I'm asking myself, why wouldn't a charge do it? And I want to say one thing with respect to Henderson. The importance of the Henderson charges is because they deal with counterintuitive notions, not intuitive notions. Because if it was dealing with intuitive notions, we wouldn't need the charge. Then it would fall within the ken. It was the things that are counterintuitive. And to the extent that delay is counterintuitive to certain jurors, that's how a jury charge can allay misconceptions without bringing in a person who's regurgitating the same script from courtroom to courtroom to courtroom, and which is not fashioned or individualized to the case.
Well, again, Your Honor, I still would say that this is different than Henderson. This does involve different kind of intuitive, counterintuitive. It just involves different things. A juror really can understand the problems with eyewitness identification or identification generally that they might not be able to understand with the child sex abuse victim.
I'm not sure.
But the third reason...
I'm not sure that's right. I think Justice Albin was correct in his summary that Henderson talks about the Tennessee study of actual jurors and their inability to assess factors like the level of confidence and how jurors had counterintuitive reactions to some of the important factors that then form the basis for the jury charge. What is it about a witness's testimony who says, I didn't want to upset my mom, I didn't want my younger brother to grow up without a dad, that is hard for a juror to understand? How do they reach a counterintuitive result from that sort of evidence?
Well, again, jurors are coming in with, we still believe jurors are coming in with these myths and these misconceptions, and when our victim's credibility is being called into question by a defense attorney, that we should be able to put an expert on the stand to explain why that happened.
In all cases, any case with a delay, regardless of the explanation that the individual witness provides, the state should be permitted to call an expert?
Well, it would depend, but yes, generally yes.
Take this case and consider our decision in Frisbee, where we said you can't call a witness as a truth sayer for another witness, that
Well,
the
of
jury
course.
is the ultimate determiner of credibility.
Of course, and as this court said all the way back in JQ and has reiterated time and time again, a CSAAS expert is not to opine as to the truthfulness of the victim. They are supposed to come in there without knowing any of the background facts of this case.
To the extent that there's a repetitive phenomenon, that is in part based upon this court's opinions that really very strictly prohibited CSAAS experts from relating the
statistics or
to the
connecting the
individual
dots,
case.
or when I argued J.R.E. before this court, bringing in certain behaviors. All of that is not okay. But I do want to go on.
But take this case where the victim comes in and explains precisely why she delayed making the report.
Well,
and at this point, what is the purpose of calling in an expert?
Well, I didn't handle this case below at the appellate division, so I'm not as familiar with the facts as maybe I should be, but my understanding of it is that this particular victim dealt with the abuse over a period of time and is then coming into court to give her testimony at a much later age. And although she is giving an explanation to the jury, that still might not get rid of the myths and the misconceptions that jurors would bring in with them when they come into the courtroom. And
wouldn't a jury instruction help?
Well, I'm going to go back then, for the three reasons. I said, first of all, that, if it still meets the requirements of 702, the state should be able to call an expert. Two, this isn't something that's inside the ken of the average juror, so it would be more sufficiently explained by an expert. And the three...
I just don't think you're giving the jury credit for being a jury, for being 6 or 12 people, depending on the case, who live a life, who watch TV, who knows what goes on out there.
But do we really...
So you've got the victim testifying, and you've got a jury instruction to the jury saying, "Look, this is not unusual." I don't understand why you need more.
Well, I really don't think we want our jurors' understanding to come from what they see on TV. Again, we can't control for what they're taking in, what kind of media they're taking in. And, it's not just news articles these days. It's Facebook. It's, comments to articles that we see on the Internet. And, I think that this still really is something the average person in their lifetime has not experienced what these child victims are experiencing. And I think the extra explanation does help. And I do have a third reason as to why the jury instruction.
So let's have the
That's
third
okay,
reason.
but I will get there now. Third, simply making this a jury instruction gives the defense really no opportunity to respond. Whereas right now, when we have a CSAAS expert on the stand, they have the ability to fully cross-examine them for all of these issues that we've been talking about today, and they also have the ability to call an expert themselves, which I know doesn't happen in all cases, but I can say from personal experience in the last appellate division, a case I worked on, the defense actually did call an expert to counter
So you're
CSAAS.
making a case for them. What if they say, "Thank you very much, but we think we're not that good"?
Well, like I said, the defense should have an opportunity to respond.
You're not asking for you're not asking for a blanket rule in any category of cases if an expert walks in, they're admitted. The court does a case specific. If there's a challenge, obviously, 702 analysis, correct?
Correct.
In any case.
Correct.
So it would be a case-by-case determination about experts.
Correct. It would still have to undergo a 104 hearing. A trial judge could very well find that the testimony here isn't needed, it's not relevant, or for whatever reason. But simply putting this to a jury instruction, I don't think...
Isn't jury instruction better? It's the voice of authority of a judge. Here's a judge giving an instruction that is authoritative. Is it going to be subject to cross-examination? Explaining why there's delay. Why wouldn't you prefer that rather than putting on your expert who's now going to be cross-examined and impeached?
Well, there's definitely a difference between us introducing an expert and then something just coming from an instruction. And jurors might not give due weight to an instruction, honestly.
No?
So if we are able to put...
I thought we assume they listen to these instructions, or are they falling asleep?
We hope they're listening to instructions, but there is certainly a difference, and that is why we call experts.
You want the ability to highlight the expert testimony rather than having it be part of a long...
And again, this court might disagree with me, but again, this is something that we believe is outside the ken of the average juror. So to be able to have an expert on the stand to provide a little bit more context or to give a little bit more of an explanation as to the phenomenon.
Can I make this obvious? When it came to eyewitness testimony, you were making their arguments. Like, this falls within the, all of these issues fall within the ken of the average jury. They don't need this extra instruction. It's like the shoe is on the complete other foot now.
Isn't that what lawyers generally do, argue this side of the case? And they're not bound by what unless it's judicial stop, but they're not bound by the other side. But
I wasn't at this office when Henderson was argued. So.
Can I just confirm one thing? We've heard from your adversaries that there is at least some consensus, they may dispute this, regarding delay. Are you arguing that based upon all of these studies that we've had in front of us, that there is also consensus on denial and recantation? That it's a substantial enough number of cases that they fall within that same category as delay?
Yes, Your Honor, and I believe we see that in the adult studies, number one, where I kind of broke it down in my notes, so if you just give me a second. Respondents who say they were sexually abused as a child never told anyone, so that would be support for delay, support for secrecy. They mention feelings in these adult studies such as embarrassment, shame, fear, things we also talk about in CSAAS, usually under the heading of helplessness.
Forget CSAAS for a minute. I'm talking about categories of conduct that there is consensus are exhibited by victims of child sexual assault.
Yes. Well, then, still going back to those adult studies, we see that it is kept a secret, that they don't disclose right away, that they do that because they feel embarrassed, they feel shame, they feel fear. That has been shown over and over again in these adult studies.
Denial, delay, recantation. 3 behaviors, not causes, because I may agree that if you're going to talk about why it happened, you better have an expert talk about why, and they better be able to attribute it to this victim. I'm talking about 3 common characteristics of child sexual abuse. Delay, denial, recantation. Are they common? Are they sufficiently statistically significant such that, whether it's a charge or expert testimony, that should come in?
Yes, and I believe the state presented clear and convincing evidence of that below through adult population studies, through child surveys.
The studies we have.
Through essentially what you guys have.
And that's largely, a lot of them are the defense studies.
Yes, correct.
I'm sorry. The statistical significance really doesn't belong in this, does it? We're not dealing with comparative studies.
No, statistical significance, and I believe I do go into this pretty heavily in my brief, would only matter if we were trying to connect the dots.
Right.
If we were trying to say that this child has in fact been sexually abused,
right,
and that's because she exhibits X, Y, and Z. We can't. That doesn't happen here.
You want to present simply data that says 33% or 20% or whatever, without comparing it to any population that's unaffected.
Yes, all that matters, especially for purposes of this hearing, with whether or not it's scientifically valid, is that these phenomenon occur with such a frequency that they can be documented.
Would you agree with I think it was your expert who said that recantation is perhaps the most hotly debated of all of these features? That doesn't sound in general acceptance by the scientific community.
I think everyone, though, generally accepts that it does happen.
In some cases.
Correct, but that it does happen. And again, because we're not...
Is that all you believe you need to show? That if it happens in some cases, no matter how few they may be, you get to call an expert?
Well, I don't want to say, I mean, if there is a difference between it not happening at all or happening 1 or 2 times and then actually having some kind of statistical significance. And I do think, although there is a variation among rates with recantation, I think it is still statistically significant. And it's not going to come up necessarily in all cases. It would depend on the victim.
I'm sorry, I don't know why you're using statistical significance.
I used it. I think I backed her into that corner. I apologize.
Yeah,
I retract
because you're not comparing it to an unaffected population. That's a causation concept.
Right, yeah, and
So
I apologize.
I think you're saying that there's a significant number, period. It's a number.
It doesn't not happen.
So do we know the other side of this? So a certain number of sexual abuse cases are recantations. That's a given, whatever the statistic is. Then there are a certain number of cases where there are recantations where there was no sexual abuse. There was an initial charge, and then there was a recantation that was truthful. I don't know what. Do we know what percentage of cases fall within that category?
Of children that are taking...
initially make a charge, recant, and the recantation happens to be true because there wasn't sexual abuse.
I wouldn't know off the top of my head as to those statistics. All I know is that 4 to 27% that we do get from
But in a study, wouldn't that also be important? Are you trying to...
Well, it's hard to determine because, and that's talked about by all of the experts, when you're talking about substantiated cases of sexual abuse versus non-substantiated cases of sexual abuse. And that's why a lot of the studies on recantation involve, a class of subjects that's very small because they try to kind of prevent all of those other outside factors from coming in and really just focus on cases where we have substantiated cases of sexual abuse either through STDs or photographic evidence.
So I get that. And I know this is a very difficult area in which to do statistical analysis. That's why I'm asking it, because you don't have another comparative group. So you may know in 23% of substantiated sexual abuse cases or recantations, but then there are cases, I imagine, where there are recantations from an original charge where law enforcement or the authorities will determine that recantation was true. Nothing really happened here.
Very true, but it would be hard for us to actually get a number for that.
So I get that, but does that impact on the validity of the recantations that you want an explanation about?
I don't think so.
Like, what does the jury know about that in terms of recantations that were truly validated?
Well, because I think our expert would be testifying that in the appropriate case that there are that studies have shown that there are some instances where children who have substantiated claims of sexual abuse, or maybe that's not even the correct terminology to use, but children do recant their allegations once they disclose. And again, we're not trying to say that we're proving anything by introducing this testimony. We're not. We're just trying to get rid... Go ahead.
Please finish your sentence.
We're just trying to dispel that the biases that our jurors are coming in, our potential jurors are coming into the courtroom with.
I know we've touched on this, and I just want to see if I could get your answer to it again. Before you can present that type of expert testimony, what do you need to present at the 104 hearing in the context of this case in order to get by the second prong of Rule 702? I don't know that it's enough to simply have experts come in and say, this happens sometimes. Would you agree that if all the expert studies said, there's recantation in some cases, but we unanimously agree that that is extremely rare, would you be arguing that you have satisfied the threshold under 702 and could introduce that evidence?
Well, again, as an expert testifying to their own knowledge and experience in child sex abuse, if they have seen this phenomenon occur, then they can give a proper expert opinion on that.
So the answer is yes. That's enough.
Yes.
Okay.
I don't believe I have anything else to add unless Your Honors have any other questions.
Thank you, Ms. Elson.
Thank you.
It's been a while, Ms. Michaels.
Yes, and you'll be happy to hear I'm just going to rest on the briefing and arguments.
Thank you. And thank you to all counsel for the very